when I call it. Court is calling 2024 CR 010525, State versus Aaron Xavier Ramirez. Can I have parties announced for the record for the state?
Nicole Thornborough for the state.
Defendant. And are you Mr. Ramirez?
Yes, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor, I believe I have.
Court will find that the state is in compliance with discovery. Mr. Ramirez?
Honor.
Yeah.
Waiting on the state.
Okay.
Right there.
Oh, someone will come up when I call it. Court is calling 2024 CR 010525, State versus Aaron Xavier Ramirez. Can I have parties announced for the record for the state?
Nicole Thornborough for the state.
Defendant.
Ramirez.
And are you Mr. Ramirez?
Yes, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor, I believe I have.
Court will find that the state is in compliance with discovery. Mr. Ramirez?
And this is where just another plea hearing quietly turns into something much bigger. Because what starts as a paperwork-heavy felony case is about to expose how one sentence, one suggestion, can completely shift a judge's view of a defendant's intent.
Did you review the document entitled Application for Community Supervision
Yes, Your Honor.
or Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do waive the reading of the indictment.
State, are you proceeding on the indictment as presented?
Proceeding only on paragraph A, Your Honor.
Any objection?
No objections, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand in paragraph A, you're charged with unlawful with the state? The court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you?
Yes, Your Honor.
According to the plea, the state is proceeding on paragraph A. They're asking that your punishment be assessed at a cap of 8 years in the prison. There's a $3,000 fine. The state is silent on your application. They're taking in consideration 2024 CR 010521, CM numbers 119820 and 119819. There's to be no contact with the complainants, and state reserves the right to
Quick legal pause here. A second-degree felony in Texas isn't minor. 2 to 20 years is a massive window, which means the judge has enormous discretion. Everything that happens from this point forward is about convincing the court which end of that spectrum this defendant belongs on.
request additional terms if community supervision is granted. That's very vague.
Well, yeah, I mean, if it depends on, as long as the additional terms are reasonable, Judge.
That's a very vague term.
Yeah.
All right, so let me explain something to you. The state can request additional terms of community supervision, but I'm the one who sets the terms of community supervision. So really, the only thing that you're in agreement with them as far as conditions of probation is that if I were to grant your application for probation, they're allowed to request different conditions. I don't have to follow the conditions that they're requesting. So the only thing that technically is your agreement is that they can ask for other things with conditions of probation. They can't come back and say, we're changing the cap of 8 to something else. You understand?
Yes, sir.
All right, did you understand that to be the plea bargain agreement?
Yes, sir.
State, is that the plea? Defense, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
When a judge calls something vague, that's not a throwaway comment, that's a warning light. Vague plea terms mean misunderstandings later, and misunderstandings in probation cases are how people end up in prison.
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There have not, Judge.
Then to paragraph A, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State Officer States Exhibit 1 and its attachments.
No objections, Judge.
Did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So here's my question. I can set this for a PSI. If I set it for a PSI, it'll probably be 8 weeks out. Or if y'all want, I really don't need a PSI, but I will give you all both a chance to have witnesses present so we could give it a quicker date. And y'all just have your witnesses present and state if there's any prior criminal history, if you'll submit that to the court.
We would request a PSI.
All right.
I think that would be beneficial, Judge.
All right, Norma, if I can have a PSI, is there any mental health issues or no?
Your Honor, my client is currently in therapy and seeing a psychiatrist, Judge.
All right, and MIC evaluation. So what date?
Excellent, Your Honor. Thank you.
All right. Court is calling 2024 CR 010525, State versus Aaron Ramirez. Can I have parties announced for the record for the state?
Samantha Lynn Brown.
This right here is a pivotal decision. A PSI, or pre-sentence investigation, is essentially the court asking, who are you really? It can save a defendant, or quietly confirm the judge's worst concerns.
State.
For the defense?
John St. Heinrich for Aaron Ramirez.
And are you Aaron Ramirez?
Yes, Your Honor.
All right, you entered a plea on January 16th to paragraph A. You entered a plea of no contest. A PSI and MIC evaluation was ordered. According to the plea bargaining agreement, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your applications, and there are different cases that are being taken into consideration. Have both parties had a chance to review the PSI and cap evaluation?
Defense has, Your Honor.
State has, Your Honor.
Any objection from the state?
No objection, Your Honor.
Any objection from the defense?
No objections from the defense, Judge.
All right, the state is silent. Defense, do you have any witnesses?
I do, Your Honor.
Yes.
First off, may I make an opening statement, Judge?
Sure.
Your Honor, my client has appeared timely for every court appearance, and he's here again today to accept responsibility and culpability for the crimes that he's committed, Judge. But if I may be allowed to offer some context to this, Your Honor.
Yes.
My client has severe, he has mental health issues, Judge. And this is not to make light or to make excuses. The victim is his childhood friend's girlfriend, Judge. My client has experienced, due to his parents leaving, and hardships growing up. His mom is a primary influence in his life and has raised him. His father's been in and out of the picture, Judge. Due to this, he's got some sense of abandonment issues. While he was growing up, his mom had moved yearly, so he's starting new schools. I think the impetus of this crime was to maintain some kind of connection to his childhood friend. When his childhood friend got into a relationship, he started feeling abandoned. This was his way to connect with him. Now, it doesn't stand logic. There are issues with this. My client has been seeking mental health treatment before this incident and after this incident. He's still currently seeking counseling right now. He's still engaged in counseling weekly, Your Honor. Further, Judge, my client is a full-time college student. He has a job, and he has never been in trouble, never had any criminal charges levied against him before. Your Honor, if I may begin with witnesses.
Yes.
Defense would like to call Miss Maria Ramirez.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Maria Rosalinda Ramirez.
Miss Ramirez, who are you to Aaron?
I am Aaron's mother.
How old is Aaron?
Aaron is 21.
He's 21 years old. Ma'am, when did you and Aaron's father separate?
He was 4 years old when we separated.
Have you been the primary influence in Aaron's life?
Yes, his father was in and out of his life. He would rekindle the relationship and then stop without any kind of explanation. So it was really hard on Aaron to kind of have that individual in his life. And I feel like I should have noticed some of those things, but unfortunately, he just always presented like being such a happy, kid that I just didn't see that he was going through so much, unfortunately. But I feel like I failed him in that part, not seeking counseling. I know now that he's seeking counseling that he has a lot of those abandonment issues and trust issues. He's been more forthcoming with his feelings, but it's really helped him to kind of express that. But he wouldn't express it when he was younger. He's never been in any type of trouble, though. He's always been very happy, very good at school, academically. And I'm not trying to make excuses for him. I know that what he did was very serious, but I just hope that the court takes his childhood into consideration and him trying his very best to kind of move forward from this situation.
Are you making any excuses for his behavior now?
Absolutely not. He's expressed to me that he wants to atone for what he did. He is remorseful. I'm just hoping that whatever the outcome of this doesn't, overshadow his whole life. He's young. He wants to continue to go to school and contribute to society. He really is a good child. He's never been in any kind of situation where he's been in trouble. So I really feel like, whatever the outcome, whatever the sentencing, he can still overcome this and still, be a good person, contribute to a society. I don't think that, his actions should just overshadow his whole entire life. Poverty level, but yet I wasn't, I made just enough to kind of get by. So I didn't get any kind of financial assistance, unfortunately. But we had to move around a lot when he was a kid. So I know it kind of hindered him from making these really deep connections with kids, when you've been in a school your whole life. But unfortunately, that was our situation. I had to move around a lot.
Was he attending different schools when you had moved?
Yeah, absolutely. Yeah, unfortunately, he had to attend a lot of different schools because we had to move to different locations based on what I could afford from year to year. So, yeah.
How many schools do you think he's been to through high school?
Like seven, yeah, at least 7. Yeah, I was usually able to stay in one place for about a year to 2 years, but unfortunately, just with my financial situation, I did have to move around to try to get something more affordable. So,
in your personal opinion, do you think that this contributed to a sense of abandonment?
Yeah, I mean, I really think that it more stems from just his father kind of coming into his life and then leaving without any kind of explanation. But it definitely hindered him from making really long-term connections with other people because he had to make friends and then start over, kind of like the military child, I guess, if you will, right? Unfortunately, but yeah. So.
Do you know one of the victims, Daniel Complex?
Yes, well, we've known him since he was about 7 years old. So they've been childhood friends for a long time.
Since he was 7?
Yes.
Dan, is there anything else you would like the court to know?
Just again, I just wanted to reiterate that Aaron is a really good kid. I mean, he's never been in trouble, and I don't feel that he had any type of malicious intent. Maybe he was feeling lonely or insecure about, his relationship with the victim, but I don't think that he did this to actually hurt anyone. So, thank you. Appreciate it.
And ma'am, do you have any, and be honest, please be honest with the court, you're under oath. Do you have any reservations that if the court were gracious enough to grant a term of community supervision, anyone who runs afoul of the law?
No. I mean, Aaron's 21. He doesn't drink. He doesn't smoke. His idea of having fun is like maybe going to a movie or playing video games. He's never been someone that's partied or associated himself with anyone that has like a criminal record or had like, I guess bad habits.
Pass the witness.
All right.
Thank you, ma'am.
Thank you.
Thank you. This is the court's issue, and it's based upon what's in the stipulation. So in the stipulation, it states, victim had asked his mother to go inside his bedroom in an attempt to help search for a pair of headphones. Victim lives with witness at the listed location where the offense occurred. As witness 1 was inside victim 1's bedroom searching for the pair of lost headphones, she located E9, researched E9 using the application Google Lens and discovered E9 is used as a voice recorder. Victim 1 contacted victim 2 and the defendant for advice on what to do with E9. Victim 2 advised victim 1 to call the police and make an offense report, while the defendant advised victim 1 to destroy E9. The defendant also offered to come to victim 1's home with his own cable in an attempt to investigate E9, and also suggested to victim 1 that it would not be in victim 1's best interest to call the police, as victim 1's parents are immigrants and a police report would jeopardize their immigrant status. That's my problem right there. So it doesn't appear, when the witnesses say that he wasn't malicious, to threaten somebody's immigrant status. This is what was stipulated to, saying don't call the police because it's going to hinder your immigrant status or it's going to jeopardize your immigrant status. That sort of says something about his frame of mind. So I'll hear your argument.
Your Honor, to respond directly to the court's statement, Judge, my client, we can see my client here visually in court. You've heard witness testimony. I believe that my client's motivations were not malicious. He's not, in that text, he's not threatening the victim, using his immigration status as some kind of leverage.
And this is the moment everything changes. Up until now, this case has been framed as immaturity and mental health. But invoking immigration status, intentionally or not, crosses into intimidation in the court's eyes. That's not fear anymore. That's influence.
Not to get him to report. My client has experienced an extreme amount of shame. Now that shame probably does not equal to or exceed the shame that the victims probably are experiencing. I can say that